Hey everyone, welcome back to the Trial Files. I'm your host, Christine Worth. Last time we wrapped up the state's direct examination of Sherry Culhane, the DNA analyst from the Wisconsin State Crime Lab. If you stuck with us through all the charts, the explanations, the exhibits, the acronyms, you know it was a lot. We heard how Stephen Avery's DNA was found on nearly every surface inside Teresa Hallbach's RAV4, from the dashboard and ignition to a blood crust by the center console. There was even a complete profile pulled from the key to her car, one that matched Avery, but didn't say if it matched anybody else. We also heard Culhane's confident conclusion that Avery is the source of those samples to a statistical certainty of 1 in 4 quintillion. But today, the tone shifts because in episode 46, it's the defense's turn. Attorney Jerome Buting begins his cross-examination of Sherry Culhane. Let's get into it. And at this point, Sherry Culhane takes the stand. It's, of course, the beginning of a new day, and the cross-examination is about to begin. And it is done by one of Stephen Avery's attorneys, Attorney Buting. And he begins. Good morning, ma'am. Good morning. I want to pick up on where you left off on Friday. And that is your opinions, series of opinions about the stains that you found in the RAV4. Okay? Are you with me? Mm-hmm. Your opinion over and over to Mr. Gahn was, do you have an opinion to a reasonable degree of scientific certainty as to whether Mr. Avery is the source of the DNA found in stains 1, 2, 3, whatever it was, right? Right. And what you are really saying is that as far as you can tell, Mr. Avery is the original source of the DNA that you find in those stains, correct? I'm saying that his profile was consistent with what I found in the stains. Right. But what you are not saying is anything about how his DNA found its way inside the RAV4. Are you? No. Your tests aren't designed to tell us how his DNA found its way into the location where you ultimately swabbed, are they? No. What you are looking for is a DNA profile, and if you find it, then you compare it to a known reference sample, in this case, Mr. Avery, right? Right. But if someone else planted Mr. Avery's DNA, or blood, or both, inside that vehicle, you wouldn't know that from these tests, would you? No. So you cannot tell this jury with any degree of certainty, scientific or otherwise, that Stephen Avery was himself ever inside that vehicle. Can you? No. No meaning correct? That's correct. All right. You also talked about contamination, and I think you used the word unintentional contamination. Do you recall a discussion about that? Yes, I do. All of the quality controls that you set up inside the Wisconsin Crime Lab are designed to deal with evidence after it arrives at your lab, correct? That's correct. You can't do anything about contamination that might occur to evidence before it gets to your lab, right? That's correct. And that would be true for unintentional contamination, such as an officer who's sloppy at the scene when he's picking up whatever evidence it may be. That's correct. Your tests and your quality control can't account for that, right? Right. And that also would be true as to intentional contamination that occurred before it gets to your lab as well, right? Correct. Once again, so you have no way through your quality control tests controlling whether or not there's some intentional, deliberate tampering with the evidence that takes place before it gets to your lab. That's correct. So if the evidence had been intentionally contaminated or tampered with before it got to your lab, your tests will not show that. Isn't that right? That's correct. Now, I'm assuming that you would agree with me on this, that normally evidence that you receive from an agency, that is police, is you are assuming that when you get it, that there's good integrity with that evidence, right? Correct. That is, you trust the police to be honest and fair in an investigation, generally, right? Correct. Just as we and the jury would trust you and other members of the Wisconsin Crime Lab to be honest and fair in your investigation, that's correct. And the reason that we can normally be comfortable with that assumption with regard to your crime lab is that you would never knowingly assign an analyst to examine case evidence who had some connection to a suspect, would you? No. And I'm sure, for instance, you yourself, if you had been deposed as a witness in a lawsuit brought by a suspect, you would not volunteer to be the person who runs the tests in that case, would you? No. And you would, if you knew that one of your other analysts was also similarly situated with regard to a suspect, you would not assign that analyst to be handling the evidence and making the tests that are done in the case, would you? Not if they had a personal attachment to anyone in the case. No. Sure, because it's important for you that your lab be objective in its results. Correct? Correct. And you are aware, you said that you go to meetings, forensic scientists test meetings, and that sort of thing, right? Correct. You are aware that some labs in other parts of the country have had trouble with that, right? Where analysts have been actually accused of falsifying results. Attorney Gunn says, Your Honor, I will object at this time to the relevancy of other labs. Attorney Buting says, Well, I think it goes to her procedures here. The court says, I'm going to sustain the objection. I think the point has been made. Attorney Buting then continues. Well, would you agree with me that if somebody in your lab was so predisposed, it would be very easy for that person to frame a suspect? Attorney Gunn then says, Objection, Your Honor, to the form of the question, and it calls for speculation. The court says, I'm going to sustain the objection. I will allow this line of questioning, but the hypothetical fact scenario will have to be a little bit more specific. Attorney Buting then continues. If somebody in your lab wanted to monkey with the evidence and plant it in a way that deliberately framed a suspect, that could be done, couldn't it? Attorney Gunn says, Objection, Your Honor, as to what he means by monkeying with the evidence. The court says it's sustained. Attorney Buting then continues. If somebody wanted to take and deliberately contaminate evidence, once it got to your lab, deliberately contaminate evidence, and let's say put or mix a reference sample from the suspect with actual evidence in the case, that could be done, couldn't it? It's possible that that could be done, but sure, in my opinion, that wouldn't happen. Of course not, because you take steps to be sure that the person assigned to the case would have no such inclination to do so. Isn't that right? That's correct. And you take steps to be sure that the person assigned to the case has no stake in the outcome of the testing itself or the case? Attorney Gunn says, Objection, Your Honor, vague question. Attorney Buting says, if she needs clarification, she can ask. The court says, yeah, she can answer that. And the witness says, I'm sorry, could you repeat that? You take steps to be sure that the person assigned to a case has no stake in the outcome of the case or the test? That's correct. All right. And indeed, it's your assumption that when evidence comes to you from a police agency, it's your assumption that the police have also taken similar stakes or similar steps to make sure that nobody connected with the suspect has been involved in the collection of the evidence, isn't it? Attorney Gunn says, Objection, Your Honor, speculation. Oh my gosh. Attorney Buting says, asking for her assumption. The court says she can answer. I mean, is he ever going to be able to actually get through his cross-examination without all of these fucking objections? And she answers. Okay, obviously, I don't know any of this for a fact, but I would make the assumption that evidence came in from the police agency was maintained integrity and collected from somebody who had no connection to the case. You would hope? Yes. Okay. Now, in this case, I believe you said that some of your duties involve case flow and case management, right? Correct. Does that also involve assigning particular analysts to a particular case? Yes. But in this case, you assigned yourself? Correct. All right. And that's a decision that you make and yours alone. Most of the time, sometimes my supervisor makes that decision, but in this case, I made the decision. All right. Mr. Gunn pointed out that you were actually the analyst who did the tests that resulted in exoneration of Mr. Avery in 2003, right? Correct. And you did that because, in part, because newer, more accurate DNA results or tests had been developed that actually excluded Mr. Avery as the source of a pubic hair? Correct. At the time the original case was worked, DNA was not available. Okay, but I want to get into just a little bit about what that involved. What you tested were pubic hairs that were found essentially in the area of the victim's privates, right? From her pubic area, yes. These are combings that are done to find any possible pubic hairs from the assailant, correct. And your test in 2003 absolutely, positively excluded Mr. Avery as the source of one of those hairs, right? Correct. There was no question about that, right? Correct. And it included or matched a fellow by the name of Gregory Allen, right? Yes. And you knew that Allen was no friend of the victim, so that his pubic hair shouldn't be found where they were, right? I really didn't have any knowledge of whether she knew him or not. No. Okay. But you knew that his hairs or that his DNA profile was registered in CODIS? That's correct. And that, in fact, he was already in prison at the time of 2003 when you did this test? That's correct. In prison for a rape that he committed after or while Mr. Avery sat in prison for Mr. Allen's crime. That's correct. Now, what Mr. Gunn didn't have you point out, though, let's get into a few other things. Although you were the one who exonerated or whose test exonerated Mr. Avery, the evidence sat at your lab for more than a year before you got around to doing the test that did exonerate him, right? That's correct. And one of the things that you, in fact, said you do is control priorities and case flow of what gets tested when, right? Correct. So had you done that test as soon as it came in, the evidence being in September of 2002, I believe, Mr. Avery would have been exonerated then, wouldn't he? Correct. So Mr. Avery sat for another year in prison because of the delays that resulted in your crime lab. Isn't that right? Correct. Another thing that Mr. Gunn didn't point out is another irony in this case. Not only were you involved in the 2003 exoneration of Mr. Avery, but you were also involved in the 1985 conviction of Mr. Avery, weren't you? I worked evidence on that case, yes. And you testified as a witness for the prosecution at trial in that case, didn't you? Yes, I testified. In fact, the trial where he had 16 alibi witnesses and was convicted included your expert opinion regarding some hairs that had been found and were offered by the prosecution to somehow link Mr. Avery to that crime. Isn't that right? To be perfectly honest, I do not remember my entire testimony from 1985. Well, I have it here if you need to refer to it, but I don't know that we'll get into that much detail, okay? I just want the jury to understand a little background, okay? Sure. You do recall that you testified generally in those terms, right? Yes, okay. And just so we understand, there were no DNA tests back in 1985? Correct. You were testifying about a type of so-called science known as microscopic hair comparison analysis, right? Correct. And the theory behind that science in 1985 was that you could take a microscope with two fields and that you could put one hair underneath one microscope field and another hair under the other, and you could examine the two of them together, correct? Correct. And the theory being that you present this to the jury anyway, that you could make some conclusions about how similar, dissimilar, or consistent one hair was to the other. Correct. And I don't mean to be jumping all over you. You were not the only person in the country doing this kind of testimony in 1985, right? That's correct. Forensic labs all over the country were bringing in experts to testify to juries about this kind of science, right? Correct. Including the FBI, right? Yes. Now, with the advent of DNA, the forensic community discovered something about those tests, right? Correct. They discovered that those conclusions or opinions that were being drawn by the experts, such as yourself, were really not all that reliable, didn't they? Correct. They have proven to be much less specific than DNA analysis. All right. And even wrong on occasions, right? Correct. So, for instance, in the 1985 trial of Mr. Avery, there were some hairs found, head hairs, I think, found on a t shirt that he was wearing on the day of this poor woman's rape, right? I don't recall exactly. Well, okay. Do you recall giving an opinion that one hair found on Mr. Avery's t shirt appeared to be similar to or consistent with a head hair standard of the victim in that case? No, I don't recall exactly. I'm assuming it's in my report, but I don't have independent recollection of that. Would you like to take a moment to review, yes, sir, a portion of your transcript? Yes, sir, I can. And then Attorney Gahn says, Your Honor, at this time, I just question the relevancy of this to the testimony that Ms. Culhane gave in this case, the relevancy in this 1985 case. And the court says, Mr. Buting, Attorney Buting says, Mr. Gahn tried to present her as a totally unbiased witness for them in the event that because her test in 2003 resulted in the exoneration, I think the jury needs to hear that she's also testified the other way for the prosecution at the beginning of the trial. The court says, as I understand your line of questioning, it's an attack on the methodology that was used at the time, not on her credibility. Attorney Buting says also a question on her opinion and the validity of her opinions. The court says, no, I'm going to sustain the objection. Attorney Buting says, all right. Oh, good Lord. But it's already out there, right? I mean, jury's already heard it. Attorney Buting then continues. Let's do it this way. Would you agree with me that at least that hair comparison, microscopic hair comparison, so-called forensic science, is one example of how science is not necessarily or our understanding of science is not necessarily infallible, is it? No. With respect to hair analysis, that was a much less objective criteria than what we use today. That was more subjective and open to interpretation, personal interpretation. The science that we use now, today, with DNA, is much more objective and much more reliable. Okay. But at the time you were presenting testimony, you expressed it in terms of a reasonable degree of scientific certainty, didn't you? In 1985, I do not remember how I stated that. Well, in general, whether Mr. Avery's case or any of the other cases where you presented this kind of hair comparison testimony, you presented opinions to juries or to courts to a reasonable degree of scientific certainty, didn't you? Attorney Gahn says, objection, Your Honor, relevancy, and asked and answered. The court says sustained. Attorney Buting says, as to which? Asked and answered or relevance? The court says to relevancy. Attorney Buting says, all right. And then he continues. When you talked about DNA and what it is and how it's examined, you mentioned, oh, by the way, before I leave that, to your knowledge, your lab isn't going around doing those providing that kind of testimony anymore. Hair comparison testimony anymore, are you? No. And neither is the FBI, right? I'm not sure about that. Okay. But going back to DNA, you said that, and I don't have the PowerPoint slides, but I think the jury can probably recall them. You showed this double helix kind of spiral thing being unwound and bracketing off certain areas of it, right? Correct. And you talked about a part that was considered a gene and a part that is not a gene or something like that. I referred to the parts that do not function as genes, and they are referred to as genetic markers. Okay. And well, I don't know if you got into this or not, but let's just briefly touch on this. When we're talking about genetics, you recognize that certain genes are inherited by everybody, right? The genes, for instance, that make humans have two eyes instead of one, right? Correct. Two arms instead of one? Correct. Or two legs, right? Yes. There were certain genes that are common to everybody, unless there was some sort of birth defect or genetic mutation, right? Correct. And so if you find a gene that determines that this individual should have two eyes or two legs or two arms, that's kind of meaningless in terms of identifying a suspect, isn't it? Well, first of all, we don't even look at those portions at all. I understand. So it's irrelevant. But if you were to look at genes that everybody has and find them in a profile, that would be meaningless? Correct. For your purposes? Yes. As you would say, they would have zero discriminating power? Correct. Okay. And other more common types of genes, however, are sort of individually inherited, like the gene that would say what color your hair should be, may be different from what someone else has, right? Yes. Or what your eye color may be, right? Correct. Or how tall or how short you are ultimately going to be when you grow up? Correct. Those are sort of more individual genetic characteristics that are inherited at different rates in the population. Correct. Same thing with whether you are type A or type B blood or type O positive or whatever. Correct. And there are data banks, then statistics that can say, what are the odds or what are the chances of finding, a random man population, somebody with blue eyes? I don't know about that. I don't know if you are a serologist, so let me focus on that. There are statistics that tell you what percentage of the population is type A blood, correct, and type B and so forth, right? Yes. And those are well-known statistics that have been developed over years of study. Yes. Now, in fact, we know or we're learning what genes actually determine someone to have certain characteristics, physical or biological characteristics, right? Yes. Some diseases we're finding are based on a particular gene someone may have. For instance, yes. Now, with DNA tests, you talked about this area that's not really what you call a gene, but you called it a genetic marker, right? Correct. And it's an area of the DNA that appears to be, I think you used the term hypervariable. Do you recall that? I don't recall using that term, but it's extremely variable in those regions. That's correct. Okay. But you also said that we don't know what that portion of the DNA is even about, why it's there, do we? No. We don't know what it does, why we would have a marker that would be the D21, blah, 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 number that you come up with in these tests. That's correct. These are just things that we think at our current level of scientific knowledge are rather unique from one person to the next. When you put them all together, well, they are variable, and that's the important part of them. They vary from individual to individual. The scientists don't know what their function is, but for forensics, the important part is that they are different from person to person. Okay. But if science later determines that they are not completely independently inherited, that they are linked together, that would really make a difference for you, wouldn't it? Yes. Because all these 1 in a quintillion or 1 in a billion numbers you come up with are based on the assumption that each one of those 16 numbers on your PowerPoint slides are inherited completely independent of each other. That's correct. That is, if someone has a D21 16, they are not necessarily going to be also have a VWA 12. Okay, so I'm going to pause here for a second because I think this needs a little bit of explanation. If I'm sitting there, if I'm one of the people in the jury and I'm listening to this, I am still confused as hell. And this is even after we've heard all about what Sherry Culhane does, how she does it, etc. But your head just has to be reeling at this point with all of these numbers and these letters. So here's something the jury didn't have the benefit of: an everyday explanation for us normal people. What the defense is pointing out here is pretty simple. although it does sound confusing as hell. I just have to say that again. Most of the DNA that we all have is basically identical. That's the stuff that makes us human, like the genes for two eyes, two arms, blood pumping through our veins. So when a DNA test is being used to identify someone, they don't look at those parts. Instead, they focus on these other stretches of DNA that scientists call genetic markers. These markers don't code for anything that we understand yet. They don't determine hair color or height or even blood type. They're just kind of there. And what makes them useful in forensics is that they vary a lot from person to person. But here's the catch. All those huge odds that you hear, like 1 in a billion, are based on the assumption that each of these markers is inherited totally separately from the others. The defense is saying, well, what if they're not? Because if science ever finds out that they are linked, those 1 in a billion numbers could be way off, and that matters. All right, let's get back to the testimony. That's correct. All right. Let's talk about the testing process just a little bit first, then we'll get into it in more detail. The jury, I think, needs to understand that the tests that you do in your lab or anyone does in your lab are not what we would call double-blind tests. Could you define what you mean by that? Or even blind tests? You never heard that term? I have heard that term before. I'm not exactly sure how you are using the term. If you could define that for me. Well, okay. Let's say on a proficiency test that you get that's sent to you from some lab, outside lab, you have no idea what you are testing, right? Correct. You have no idea what's the suspect sample, what's the elimination sample. You don't know any of that when you do the tests, right? Well, on a proficiency test, we know what the suspect and we know what the victim are. Okay, so those aren't completely blind either. Let me give you an example what I mean by blind. Someone gives you a sample, two reference standards, and you have no idea who the suspect is and who the extremely unlikely elimination sample is. Okay, all right. And then you get an evidence sample that's also unknown at that time, correct? If you just got those three samples and you are just testing them, you have no idea which is which. That's what I mean by blind testing. Okay. All right. That's not what you do in your lab. No. In your lab, when you get a reference sample, you know, in fact, you usually know the name of the person whose reference sample you are dealing with. Yes. So when you test Mr. Avery's DNA sample, you knew it was Mr. Avery who you were testing. Yes. Or Dolores Avery in her case. Yes. Or Alan Avery in his case, right? Correct. And you know that, and not only do you know who it is you are testing, but you have some idea whether they are considered a suspect in the case or not. That's correct. You know that because you talk with police and prosecutors. That in part, and it comes into the laboratory with a suspect and a victim's name. Oh, okay. So when you get it, you already know who the suspect is? If there is a suspect, yes. And in this case, there was a suspect. And the name given to that person was Stephen Avery when it came to your lab. Isn't that right? Yes. Not only that, you get messages, and phone conversations, in this case with Mr. Fassbender, right? Yes. And he kind of gives you a heads up on what to look for and, you know, what happened, what they think happened in the case or at the scene. Correct. And in this case, you got a number of phone calls and messages from Mr. Fassbender kind of early on in the testing, right? Yes. I'm showing you Exhibit 341. Does that form look familiar to you? Yes. This is something that's called a case communication record. Yes. Something that you use in your lab. Correct. And what you do is when you get a phone call from somebody, you will keep jotting notes as to the gist of the conversation. That's correct. And did you do that in this case? Yes. Is that your initials at the top? Yes. Let me put this up on the Elmo. There we go. All right. I apologize for the delay. Up on the screen now is Exhibit 341. And this is one of those phone messages that you got from, in this case, Mr. Fassbender, correct? Yes. You've got a place to indicate that where it says you check incoming, Fassbender's name, and the date of this is November 11th of 2005, correct? Yes. And the very first thing that is indicated on here is he is telling you that there's some evidence that is going to be coming or is already here, right? Yes. Here meaning at your lab? Correct. And he says that there's going to be a couple of items from the house and the garage, right? Right. And then he says, or you wrote down, I assume that's him telling you, try to put her in his house or garage. Correct? Correct. So you are being told before you do any of these tests that Mr. Fassbender wants you to come up with results that put Teresa Hallbach in Mr. Avery's house or garage. Isn't that right? I had that information, but that had no bearing on my analysis at all. Of course not. But that's what you are being told to do. That was information in the investigation. That's what Mr. Fassbender told you he hoped you would be able to do with your tests. Isn't that right? Yeah, I assume so. Okay. You also had some emails with Mr. Kratz, correct? And I'm going to just interrupt here because I'm sure if you've been listening along, you know who Kratz is, but Kratz is actually I guess you'd call him the head prosecutor for this entire case. And he's usually been there asking the questions. In this case, for Sherry Culhane, he didn't, but that's who he is. And she says, yes, that she had some emails with Mr. Kratz, and the questioning continues and says, actually, before we get to that, let me do one more here. I'm showing you Exhibit 342. Would you be able to identify that for us? Yes. That's another one of those case communication records? Yes. But this one, though, is dated December 15th? Correct. Concerns another phone conversation with Mr. Fassbender? Yes. Mind if I put it up on the Elmo now? No. This is, again, an incoming call where Mr. Fassbender is calling you, right? Yes. Now, the first entry, we should clarify a little bit. It says swab keys and collect swabs. No need to analyze at this time, right? Correct. Just so we're not confused, the jury is not confused. That is not in reference to this Toyota key that was brought to you earlier, right? Correct. That was a completely separate test that was done. This is some other keys that they brought to you. Yes, this was referencing some additional keys. It also says, like a couple days later, 4 days later, that Mr. Fassbender wants you to swab handcuffs and leg irons, right? Yes. As well as the license plates from the RAV4 and to check the .22 caliber gun, item DD, for any indication of the victim's blood on the barrel, right? Yes. And also to swab the trigger guard area to compare with Steve Avery, correct? And we'll get into this with a little more detail with some of the other things first. But as long as we're at these phone messages, let me just clear this up. You did do that in this case, right? Yes. You swabbed the handcuffs and the leg irons? Yes. And you found no DNA of Teresa Hallbach on those items, did you? No. And you swabbed the license plates, and you found no usable DNA that you could draw any conclusions from, right? Right. And you checked the item DD, .22 caliber gun. That's a rifle, right? Yes. You looked for any blood of the victim on the barrel, right? Correct. You found no DNA of Teresa Hallbach on that barrel? Correct. You looked at the trigger guard as well. Not just the trigger guard, but the trigger itself? Yes. You swabbed both, right? Yes. And you found no DNA of Mr. Avery, right? Correct. Okay. And as to the handcuffs and leg irons, you did find some DNA on it though, didn't you? Yes, I did. You found Mr. Avery's own DNA in a mixture sample? Yes. In a mixture with some other male, right? I can't tell for sure whether it was a male or a female. Well, it wasn't a mixture with Teresa Hallbach? Correct. And the fact that you found DNA of any kind on the handcuffs is an indication to you that they hadn't been wiped down with bleach, isn't it? That would be correct. Okay. And you, of course, had no way of knowing how old that DNA that you did find from Mr. Avery on those handcuffs or leg irons was, right? Right. That's one thing about DNA. When you find a profile, you can't tell when it is or when it was originally deposited, correct? Yes, that's correct. You find DNA sometimes in mummies thousands of years old. That's correct. Okay. Now, I have used the term elimination samples today. I don't believe you used that term yesterday or Friday. Do you recall? I don't recall. With Mr. Gone, you referred to samples as exemplars or reference samples, correct? Correct. That's because the term elimination samples has a meaning behind it that the others don't. And that's correct. Elimination sample is something that you refer to when you are just trying to eliminate somebody as a source. Correct. And that would be, excuse me, that would be a situation where it was a case and perhaps you knew that someone's DNA was there ahead of time. And the elimination sample, for instance, in a sexual assault case, and someone had consensual sex, then you would have an elimination standard from that consensual sex partner. Right. So in that circumstance, there would be, it's just sort of assumed, there's really no question or doubt that the sample that you are looking at has nothing to do with the case. It just helps us sort that out if we find a mixture of DNA. An elimination sample would help us sort out who the possible contributors are. Right. With the understanding that that person you are trying to eliminate is not a suspect. Correct. Okay. Attorney Gunn then says, Your Honor, the state would like to be heard on this outside the presence of the jury. And the court says, Very well. At this time, we'll excuse the members of the jury for the court to hear argument. And then he tells the jury to not discuss the case or any portion of the testimony. And at this point, the jury leaves. The court says, You may be seated. And Attorney Buting says, May I go ahead and mark this so we know what we're talking about? I will mark this one because it's not highlighted. And then exhibit number 343 is marked for identification. He then continues. Just by way of explanation, what I'm attempting to do at this point is show Miss Culhane an email that she received. I guess it's from Mr. Kratz. I do not intend to actually offer this I don't intend all the content of this email to come into the case or to be sent to the jury. But I do wish one particular line of it where Mr. Kratz is telling the witness certain samples that he refers to as elimination samples. That's my only purpose. I don't know if counsel objects to that limited use. Wonder what the rest of that email says. I'm going to interrupt here because after I finished recording this episode, I found the email. I actually found it. I had to. So here's what it says. It is from Ken Kratz. It's dated Tuesday, February 7th, 2006 at 1:16 p.m. to Sherry Culhane regarding the Stephen Avery case. And it starts, Thank you so much for your quick response. Sounds like you've got everything handled. I spoke with Mark Wiegert and he mentioned he called about swabbing the trigger portion of the gun for DNA, then sending it off to the tool mark guys. Thanks for doing that. Thank you also for testing all the stains in the SUV. That will be a huge weapon against the claim of planted evidence. The STR PowerPoint I found is pretty basic, and I don't intend to go into a lot of the science of the DNA analysis for the jury. This is consistent with the way Norm does it, and this would be Norm Gone, the guy who was asking the questions of Sherry Culhane to begin with. I still don't understand the two new markers, penta E and D. What chromosomes are analyzed/inspected/associated with these loci, LOCI, question mark? I'm sure you'll explain what 5 base pair repeats means at the necessary time, so we don't have to go into that now. Can you identify the 7 loci, I think that's how you say that matched on the tissue analysis? Most of what will be presented at trial will be computer-based exhibits, PowerPoint. So although we can develop charts and the like, we'll need to do that in a computer format Then just print out a small page to have marked as the actual exhibit for court. Mark Wiegert is checking the 1985 Manitowoc blood sample taken to make sure what it was. So you tested that sample back then? How bizarre is that? Were you also the analyst that got him out of prison in 2003? I understand the frequency point on the mtDNA match. It's amazing. However, how much weight the public attributed to finding that locally, that, quote, the FBI confirms that the human remains are that of the victims, unquote, exclamation point. We were careful not to say that at all, but perceptions are what they are. On that topic, didn't the RFLP testing use Cephin loci for a quote unquote match? I do not need your profiles generated on all the results. The way you did your last report is fine, lumping all the profiles that were from each respective source together. The only thing I do still want is a profile developed for the 3 men that submitted elimination exemplars. And in parentheses, it says Chuck Avery, Earl Avery, and Bobby Dassey. I totally understand that your protocol suggests that you stop developing elimination profiles when you have a match. But in this case, the only men on the property when the victim was killed included the defendant, Stephen, and his 2 brothers, Earl and Chuck, and his nephew, Bobby. I want to be able to show the jury what these profiles look like and show them they do not match the blood recovered from the SUV. I know this seems overly sensitive to the, quote, CSI effect, but it eliminates a whole line of defense questioning and possible jury confusion as to why it wasn't done. Here's the good news. I don't need that done right away. Anytime by May or June would be just fine. Does that sound okay? Please send the elimination quote-unquote profiles themselves so I can include them in the exhibits. So just those 3 exemplars, since Barb and Dolores can be eliminated on XY alone. And I think that's all I need. Never thought you'd hear that, hey? Send your reports when you can, and call or write if you need anything else. I'll be talking to Norm, again, Norm gone, and we'll make an appointment when it's convenient for you. Thanks again, Sherry. Ken. So in a nutshell, here's what he's saying. So first, this is kind of a behind-the-scenes note from the lead prosecutor to the state's DNA analyst, thanking Sherry for various tasks like swabbing the gun, testing stains in the SUV, helping prepare exhibits. He's coordinating how to present the DNA evidence in a way that's clean, simple, and in his words, a huge weapon against the claim of planted evidence. But then the email veers into territory that for a defense attorney is gold. Kratz asks for something extra. DNA profiles from Chuck Avery, Earl Avery, and Bobby Dassey. These were family members who lived on or near the property, and he refers to them as elimination exemplars, meaning technically samples submitted to rule people out and not test them as suspects. But here's the catch. Kratz acknowledges that according to lab protocol, they normally wouldn't run those tests. Because once a match is made to Stephen Avery, once his DNA is found, they stop testing the others. The science says the match is made, case closed. But Kratz essentially says do it anyway. Why? Not because the evidence demands it, but because the optics do. In his own words, it would eliminate a whole line of defense questioning and avoid jury confusion. That's not a scientific justification, that's a strategic one. And for the defense, this is the entire argument, that the investigation, especially the forensic process, was shaped to confirm what the prosecution already believed, not to test the evidence neutrally, but to make sure that no loose ends threatened the story that they wanted the jury to believe. Now, is this shady? Well, that's kind of up for debate. It's not illegal for a prosecutor to communicate with a lab analyst, and Kratz is careful. He doesn't order Culhane to change her conclusions. He's polite, he's professional, he's even friendly. But it's also not neutral. He's framing the DNA evidence as a weapon. He's asking her to go beyond standard protocol. And he's clearly thinking about how to present the case, not how to explore all possible scenarios. This isn't how science is supposed to work. Prosecutors should be truth seekers. They're supposed to follow the evidence, not shape it. And this email shows Kratz doing the opposite, steering the science toward a narrative that fits. And one thing that I had a question about, that FBI remark, right? It's a revealing side, because Kratz says, it's amazing how much weight the public attributed to finding that DNA locally that the FBI confirms are the victims. We were careful not to say that at all, but perceptions are what they are. He's talking about the perception that the FBI confirmed Teresa Halbach's remains. But here's the thing, the FBI didn't confirm that. That match came from a mitochondrial DNA analysis, less specific than STR testing, and it was done at the state level. Kratz admits that they were, quote unquote, careful not to say that the FBI confirmed it, but he also notes how powerful that impression was in the media and the public eye. It's kind of this nod, I guess, to the gap between courtroom facts and public perception, and it shows that Kratz is aware of and quietly relying on that gap. Now, why does this email help the defense? Well, the email would have helped the defense argue that the lab wasn't operating independently. It was being steered, even subtly, by the prosecution. That alternative suspects like Chuck and Earl and Bobby were not seriously considered, only cosmetically, and only to kind of preempt any criticism. The testing was shaped by what would look good to a jury, not by what the science required. And it reinforced the idea that the state wasn't just presenting facts, they were managing a story. And the story they wanted was simple. It was Stephen Avery, only Stephen Avery, end of investigation. But real investigations don't work like that. And that's what makes this email so critical, because the jury never saw it. Anyway, I thought that was incredibly interesting. Let's continue. The court then says, Mr. Gahn. Attorney Gahn says, can I see that again, please? And Attorney Buting says, I don't know if we need to send the witness out at this point. If there's any lengthy argument, we will otherwise. The court says, I guess I'm anticipating the objection. If it's what I'm thinking it's going to be, I don't know that it's necessary to send the witness out, but I will defer to the attorneys on that one. Attorney Gahn says, our position, Your Honor, is that this email is dated February 7th, 2006, and this is well after charges being brought in the criminal complaint against Mr. Avery. This is clearly work product on the part of Mr. Kratz. He's talking to his witness, Ms. Culhane, and basically talking trial strategy, how to go about the case, testing certain exemplars or items of evidence, and it's just clearly a work product. Attorney Buting says, Judge, first of all, if it is a work product, that privilege is waived by turning it over in discovery, in my view. But I'm not really getting into work product, and I'm sensitive to that concern, and I don't usually like to use emails in court at all. But here, I'm simply using it for one limited purpose, and that is her understanding of the characterization of specific samples as being elimination samples. Those are Chuck, Earl, and Bobby. And that's really all I want to get into with this particular document. And the court says, seems to me that point can be made without reference to this document. Attorney Buting says if she can recall it, and if she can say she's aware that they were described in those terms, sure, we can do that. The court says, does the state have any objection of letting the witness take a look at the email before she testifies, and then we can bring the jury back in without introducing the email? Attorney Gahn says, that's fine, and the court says, all right. And Attorney Gahn says, as long as Mr. Kratz is not going to be mentioned in your question that Chuck, Earl, and Earl's samples could be considered elimination samples. That's all you want to say? Attorney Buting says, we could just say submitted by the state, whether it's police or prosecution is not disclosed. The court says, I may be wrong, but I thought there's been evidence already about elimination samples taken from other members of the Avery family. So I don't think the subject matter is a problem, and I don't see a need to phrase the question such that it would involve any attorney-client work product. So let's have the witness take a look at the email if she needs it to refresh her memory. And I then think the question can be asked without suggesting that it involves conversation with the attorneys. Yeah, of course not. Wouldn't want to do that. All right, Mr. Buting, I think you can retrieve the document now. I believe the witness has reviewed it. Attorney Buting says, okay, are we ready to go? Attorney Gahn says, are there additional emails that you intend? Buting says, nope, this is all. Could I just look at that one more time? Sure. There are other items that I'm not going to introduce. We're ready to proceed, Your Honor. And the court says, all right, Mr. Buting, do you want to retrieve the document you gave the witness? Yes. And just so the record is clear, I'm not going to offer this as an exhibit. It's been marked for the record, but this will be one of those where it's just part of the record, but it's not evidence in this trial. The court says, very well. Attorney Buting says, is that fair? Okay. And then at this point, the jury is brought back in. The court tells them they may be seated, and Mr. Buting continues his questioning. Now, Ms. Culhane, you received a number of samples, not just Mr. Avery's, to compare the various pieces of possible evidence in the case, right? Correct. And when you received a sample that is a DNA standard of Chuck Avery, first, let me establish that you did. You received an exemplar standard of Chuck Avery, Earl Avery, and Bobby Dassey, right? Yes. Among some others? Yes. Like the parents, Mr. and Mrs. Avery? Yes. Right? And when you received those samples, you were asked to do a profile for each of them, right? Yes. And when you were asked to do a profile for each of them, those samples were referred to you as elimination standards, correct? Yes. Which, to your mind and your understanding, would seem to indicate that you were not to consider any one of those three, Chuck, Earl, or Bobby, as suspects? That's not entirely correct. When I'm submitted a standard, it doesn't really matter if you call it an elimination standard or a reference sample. If it fits the profile, the evidence sample, then it's reported on. If it's a match, it's reported on. Whether it's submitted as an elimination sample or as a reference standard, it's interpreted in exactly the same way. So if any of those elimination samples or reference samples are excluded, no matter what the evidence is and no matter what you call them, then that's how it would be reported. Sure. So if you get something that is told to you by the police as an elimination standard and it hits, it matches some kind of crime scene evidence, you are going to report that, of course, right? Yes. But the very fact that the items come to you with that designation, elimination standard, tells you something about what the police theory or what they believe that those samples relate to, whether they are a suspect or not. Correct. Okay. Let me go back for a minute and talk about your background. I don't recall what exhibit it is that is your curriculum vitae, but I just want to clarify a few things. You have got a bachelor's degree in biological science. Is that right? Yes. And you actually went to two colleges, though your first college was Millsaps, Millsaps College in Jackson, Mississippi. Yes. You went there for just 2 years. Yes. And then you transferred to Mississippi College to complete your undergraduate education, right? Correct. Are you originally from that area? Is that why you were going to school down there? Yes, I'm from Jackson. Okay. And then you got your Bachelor of Science in 1978? Yes. You did not go on to get a master's degree, right? Correct. Never in all your years since have you gone back to try and get a master's? That's correct. I don't see anything in your CV that shows that you worked as a research scientist, right? No, I didn't. You have little or no publications in the field? No, I have no publications. Okay. And I don't see in here that you do any kind of public speaking or teaching to other forensic scientists outside of your own lab in Wisconsin. Actually, I did present a paper at one of the Promega users meetings because we were involved in the original validation of the PowerPoint 16 kit. And I did present a paper at that meeting. Okay, but that's the only time? That's correct. And we'll talk a little bit more about validation in a few minutes. It's not really clear to me what jobs you had before you came to Wisconsin. Was it just working at the Jefferson Parish Sheriff's Office Crime Lab, or did you have some other employment between 1978 and 1984? No, I worked at the Jefferson Parish Crime Lab for 2.5, 3 years. I don't remember exactly. Then I came to Wisconsin. And then after a year I was in Wisconsin, I was hired by the crime lab. Okay. And now it's been 23 years that you have been on the job at the Wisconsin Crime Lab. That's correct. And your current title is DNA Technical Unit Leader. Yes. A position that you were appointed to in 1997. Yes. Now, is that a position that requires, well, obviously, it doesn't require a master's degree, right? Actually, it does. At the time frame when I was appointed to this position, the DNA advisory board offered was referred to as a waiver for individuals who had a certain amount of experience in forensics. In order to get that waiver, I had to go back to school and take molecular biology, statistics, and biochemistry classes, which were all at UW-Madison or online. Okay. So those requirements were filled. Now, anyone after a certain period of time, it does require a master's. Okay. So you were sort of grandfathered in with this other way of getting some additional educational miles, right? Right. And because of my experience. Okay. So it's kind of a seniority thing too, because you have been there longer than most people. Because I have experience, that's correct. Okay. Now, this current position as technical leader, you discussed as having some administrative duties, right? Yes. And also some training duties. Yes. And then also some actual DNA testing. Correct. Can you tell me what percentage of your job involves each? Probably 70% is actual casework. The duties with training varies according to how many people we have in training. When everyone is trained and there are no new analysts, then I don't have any training responsibilities. But when we hire a new analyst, then I do spend a considerable amount of time training them. Overall, I would guess 70% is spent on casework. So about 30% less caseload generally than the other analysts. That's correct. Okay, let's talk about quality control, what you know about it in your lab and just in general. You talked a lot about accreditation, right? Yes. How important that is? Yes. How rigorous the process is? Right? Yes. And one part of that is, in fact, a big part of it, is these outside auditors, whatever you want to call them, outside overseers, look at the protocols that you are using to do certain tests, right? Yes. And there's various, I assume, accrediting type boards in different forensic fields. I believe there are several different accrediting institutions depending on what type of work. There's one for paternity testing. Most forensic labs have an ASCLD accreditation. Okay. And certainly part of that is DNA protocols, right? Yes. But more than that, it's also what other kind of test protocols your lab is following. Are you referring to other sections? Yes, other sections. Yes, each section has their own protocols. And then we have lab-wide quality control standards that everyone follows, basically the same. Okay, so for instance, fingerprints, whatever that's called, identification division, yes, they have a specific protocol or number of steps that they follow in order to come to a conclusion, right? Correct. Ballistics, the same way? Yes. DNA, the same way? Yes. And like trace, let's say one subsection of the trace division seems to be like volatile chemicals. I believe so. So in other words, in order for, let's say someone brings in evidence from an arson, and the crime lab is asked to do these chemicals tests to determine whether there might be volatile chemicals like gasoline or something like that. I believe so. Okay. And there's a protocol that they have to follow in order to do that test. Yes. And these protocols are developed after a lengthy process, right? Correct. They are peer reviewed. Yes. And peer reviewed means that they are published so that other scientists, even in other parts of the country or world, can also try the same protocol and see if they get the same result? Yes. They want to replicate. They want to be able to do the very same tests elsewhere and find that the results are valid and reliable? That's correct. And it also allows laboratories to compare results and exchange information. Okay. And that's part of the scientific process? Right. Just in general, the whole idea that someone comes up with a theory until it can be tested and repeated by others is just a theory, right? Yes. And it becomes science after others have been able to test the theory over and over and replicate it, right? Yes. And sometimes that can take years before something rises to the level where it's considered science in the community, right? That would be correct. And that's true of protocols. A protocol is a plan, basically, a plan or method in which to test some item to get to a particular end result. Would that be fair? Yes. And those can take years, certainly months, sometimes years, to test over and over and over to be sure that others can get the same results. Well, most of the time when we're introducing a new protocol, it has been tested by, like, if the company that would provide the reagents and the equipment that we use to test it. And that would be a development validation. In our laboratory, we don't necessarily go through a developmental validation, which would be more like research. We basically test it to make sure that it works in our laboratory, and that doesn't really take years. Sure, but the development in your example, was a reagent or use of a reagent. But development by that chemical lab can take quite a while. Yes. And you don't pick it up as something to use in your lab until you are satisfied that it's been tested, retested, and it's a valid reagent. Correct. Now, these audits you mentioned, these audits are something that are done for government labs as well as private labs, right? I believe so. So it's not like government labs are somehow exempt from the usual examination of auditors just because they are government, right? Right. We don't just say, we're the government, trust us. That's correct. You guys have to prove your validity, your reliability scientifically, like any other lab. Correct. That's true of the state of Wisconsin crime lab, right? Yes. It's true of all government labs that you are aware of. If you're accredited, we all have to follow the same rules if you are accredited by ASCLD. Okay. And this whole accreditation process involves auditors at the very beginning, getting the protocols, the test plans, and reviewing those before they ever get into your lab, right? That's correct. And only then, if those protocols pass the peer review, at least that level of peer review from outside auditors, do they even take the next step of coming to your lab? Well, our protocols are set in place and they are given to the auditors so that they are familiar with our procedures before they come to the lab. And then when they come to the lab, they verify that we're following our protocols. So if you came up with a brand new protocol, never before done anywhere in the country, and you sent it off to these auditors and it had never been peer reviewed, what do you think they would say? Attorney Gunn, this is very speculative, no foundation. The court says, I'm going to sustain the objection. I think this might be more related to some other issue that doesn't involve this witness. Attorney Buting says, well, I think this witness can testify. She's a scientist that was involved with quality control in her lab. I think I should be allowed to explore her understanding and knowledge of the development of protocols. The court says, I don't think it's specifically related enough for the topic for which it's being introduced to be relevant. So I'm sustaining the objection. Attorney Buting then says, okay. Have you ever, in your lab, submitted a brand new protocol for a test that had never been done anywhere else in the country? I can only speak to what's been done in DNA. I don't have knowledge of any of the other sections or what they have done. In DNA, the protocols that we use have been peer-reviewed and validated, developmental as well as the internal validation. All right? And so you are comfortable with the protocols because of that? Yes. And you would not submit a brand new protocol, never done before, for your DNA test and expect to pass accreditation with that, would you? Attorney Gahn says, objection, Your Honor, to the form of the question. The court says sustained. He then continues. All right. So let me move on a little bit. Your auditors come after they get the protocols and they check out the lab, right? Yes. They check out the analysts by way of proficiency tests, correct? And they also check out security and that whole process? Yes. Like chain of custody? Correct. Let's talk about that for a moment. Wisconsin's crime lab's chain of custody procedure, I believe you testified the agency submits it, usually police, bring it into your lab, some central gathering person, right? Yes. What do you call them? We have 3 evidence specialists. And what they do is they look at the evidence. You said they make sure it's sealed, right? Yes. They give it one of these numbers, or you call them numbers, but they are often letters, right? Well, a lab number refers to the whole case, and then an item designation and a letter. Okay. So the lab number in this case is, well, I don't expect you to have it memorized, but it's M052467. Yes. Okay. Then you do have it memorized. And then as the items come in, they get named or designated. Item A, B, C, all the way through the alphabet. Right. Then they start getting called AA, AB, AC, all the way through the alphabet that way. Yes. Where do they go after that? B, BA, BB, BC, BD, and you keep on going? Right. And in this case, probably you got higher designations than any other case that's ever come to your lab. I believe that's correct. 350, you said, right? About that, yes. And when that happens, when it first comes in, this evidence specialist not only gives it a designation, but then fills out some kind of form that verifies the evidence has come into the lab, right? Yes. And at the end of the case or whatever, at whatever point your lab decides to send the evidence back to the submitting agency, they submit another or fill out another form, right? Yes. And that form is called an evidence release return form. Yes. Attorney Gunn then says, again, Your Honor, we're going to have to be heard on this. And the court says, all right, members of the jury, I think what I will do at this time is excuse you for your morning break, and we'll resume with testimony after the break is complete. I will remind you again not to discuss this matter during the break, and at this point, the jury is excused, and they're obviously not present. The court says, you may be seated. Attorney Buting says, excuse the witness, please. And the court says, I'm going to excuse the witness right now. You are excused. Mr. Gahn? Attorney Gahn then says, Your Honor, Mr. Buting has presented a form here from the used by the crime lab. It's an evidence release return form. But again, I guess I would like to see an offer of proof of where we are going with this 1985 case. This had to do with the 1985 case when that evidence was returned, to whom it was returned, and I just failed to see the relevancy of going down this road at this point. And the court says, can somebody give me a copy of the offered exhibit? Attorney Buting says, should I mark it? The court says, I think we should mark it. Attorney Gunn says, my understanding, Your Honor, is that they have stated their defense. It's this planting of the blood vial, and this has nothing to do with the blood vial or anything remotely connected. Attorney Buting says, Judge, what it is a record regularly kept in the course of her business. She's going to be able to easily identify it. She's talked about the 2003 exoneration. It shows that Mr. Avery's buccal swabs, the court says, is your microphone on? Attorney Buting says, yes. It shows that Mr. Avery's buccal swabs that used to be in the custody of the crime lab were sent back to the Manitowoc County Sheriff's Department in 2003. The court says, all right, I had understood that the blood that was in the clerk's office was going to be the subject of the defense. How does this exhibit relate to that defense? Attorney Buting says, well, this witness has testified that there's DNA found on items that she said she didn't see any blood, which could have come from buccal swabs. So she's already testified to that. So it's in play, whether or not the Manitowoc Sheriff's Department had any of Mr. Avery's DNA in another form, which they did. The court says, do we know if these items, which on their face at least say they are still sealed somewhere in the sheriff's department office. Attorney Buting says that would be the subject of testimony later, I suspect. But at this point, all I'm doing is showing that they are not still at the crime lab, that they were sent back to the submitting agency, in this case, Detective Remacher. The court says, Mr. Gahn. Attorney Gahn says, well, Your Honor, I guess I don't understand what's happening here. Now, are we switching that the planting did not come from the blood, but the planting now came from the buccal swabs of Stephen Avery? Are they switching and changing their theory of defense, that it's no longer from the blood vial that's in the clerk's office, but now the planting took place with buccal swabs of Stephen Avery? Attorney Buting says, Judge, this is not new. We have alleged, look, they brought up on direct that there was DNA she discovered that she said did not appear to come from blood. So it had to come from another source. This is another source that, according to this record at least, was sent back to the Manitowoc County Sheriff's Department. And we will tie it up later when we establish that it is, in fact, still in the Manitowoc Sheriff's Department, or at least it was as of October or November 5th, whatever, 2005. Attorney Gahn says, Your Honor, I guess their offer of proof in this case, which the court required, and in their offer of proof, it was the planting was done by the blood vial. As simple as that. That was it. Now they are going off on this buccal swab now, and that the planting may have come from there. And Attorney Buting says, Judge, I don't mean to cut counsel off, but it is in response to testimony they elicited here that some of the DNA apparently did not come from blood. Now we have a right to respond to that, and this is a response. It is not an explanation for the blood in the RAV4. The court says, right. Attorney Buting says, maybe an explanation for some of the other. The court says, my recollection is that the previous contested hearing involved the blood vial. I don't know that I was asked to rule on anything other than the vial. I believe the evidence first came up at that point that there was some DNA evidence of Mr. Avery, apparently not from blood, that was found, if I recall correctly, on the Toyota key and on the hood latch. And so I don't think I can say that this exhibit would not be relevant. The state is free to show in rebuttal or as part of its case in chief that these samples are still sealed somewhere in the sheriff's office. I think it is relevant. So after we get back from our break, I will allow the defense to pursue this matter. Attorney Buting says, thank you. What time did you say? And then the court says, let's come back in 15 minutes. And at this point, recess is taken, and we are going to end this episode and pick back up with the cross-examination again in the next episode. So here's where we are. We've just heard the beginning of the cross-examination of Sherry Culhane. Very detailed, very interesting. But underneath all of this is, how does Stephen Avery's DNA get onto key pieces of evidence? And can we trust the process that determined that? Her testimony seems solid, right? She's methodical, she's experienced, she's professional. The prosecution clearly wanted the jury to see her as the scientist who helped to free Avery in 2003, kind of this built-in credibility. But when the defense brought this up, a different picture started to show up, right? She was also involved in the 1985 case that wrongfully convicted him. She testified then, too, that they used forensic methods that we now know were unreliable. She was part of the problem then, and then years later, part of the solution. And here in 2007, she's at the center of all of this again. And the jury heard all that. But what they didn't hear is just as important, like that email, right? That moment in the testimony where the attorneys huddled in that sidebar out of earshot of the jury didn't get to hear any of this. The defense had an email from the lead prosecutor, Ken Kratz, and he had sent this to Sherry Culhane. They wanted to use it, not the whole thing, just a single line, because it called certain DNA samples elimination samples, and those were Chuck, Earl, and Bobby, Avery's relatives. And if those samples are submitted to the crime lab as elimination, it sends a message, not evidence to scrutinize. These are not suspects. They're just background noise to rule out. But the prosecution was like, hey, we don't want that line or that email in front of the jury. They called it work product. Well, technically, they said, yeah, it's work product, but they should be able to have it out there because it's work product, right? But they didn't want, I really think, and I can't recall quite exactly, but I really don't think that they wanted Ken Kratz's name brought up in that. That's just my gut feeling. I don't know. That's not evidence. It's not stated in testimony. It's just what I felt. But this whole email thing is where it gets kind of tricky because legally they may have had a point, but the psychological effect is undeniable because if you're a juror, you're relying on this lab to tell you what's real. You don't get to see the behind the scenes nudging, right? The shaping of this is how you should testify. You just see the results delivered with, scientific certainty. And that email suggested that something may be in it the prosecutors didn't want the jury to hear. That from the beginning, certain people were off the table, not because of the science, but because of the story. It's a subtle thing, but in this case, it matters. We also learned through these sidebars that Avery's buccal swabs of his saliva that was used for DNA reference, had been returned to the very department accused of framing him, Manitowoc County, in 2003, 2 years before this case began. That information, too, was almost kept from the jury. It only came in after another round of legal argument outside of their presence. So what does this all mean? Well, it means that the prosecution built its case on the reliability of the lab, on the credibility of its process. But they also fought repeatedly, oh my God, repeatedly, to keep the jury from seeing how that process was shaped from these emails, from hearing the language that was used behind the scenes. And not to protect the science of it, but to protect the perception. And that'll do it for this episode. We'll be back with more of the cross-examination in the next episode. Thank you so much for listening. I appreciate each and every one of you. We'll talk soon. Bye for now.